Starting this edition of Live and Breaking with more details coming in from the Madhya Pradesh High Court, which is essentially allowed a survey by the Archaeological Survey at the Bhojshala Temple, also known as the Kamal Maula mosque. The Hindu side had basically moved the court seeking to a survey to determine the true character of the place, which is treated as a mosque. Remember, this was given at a time when the Hindus essentially have been arguing that the Bhojshala is the temple of goddess Vagdevi, while the Muslims treat it as Kamal Maula's mosque. Remember, in the past too, we've seen tensions prevailing in Dhar several times over this entire issue, particularly when Basant Panchami falls on a Friday, as Muslims offer namaz at Bhojshala and Hindus queue up to offer prayers. Now, in September last year, the security had also been beefed up in the area near the idol of Vagdevi, which was placed inside the ancient building. Now, the idol was later removed by the police. So now, with the ASI stepping in, a survey would be carried out on the lines of what we saw in Gyanvapi. Let me also bring in Vishnu Shankar Jain, who's also argued this matter in the Gyanvapi case. As far as Bhojshala is concerned, this has been a long-standing dispute. Vishnu Shankar Jain, let me first begin by asking you, the contention that the Hindus had on this entire issue, what is it in terms of evidence that has been provided?
It was built by Raja Bhoj, which was of Parman dynasty in 11th century. And after this temple which has been built, there are historical records to prove that this temple was demolished by invaders in the past. So we had all this historical research and historical version. Apart from that, the Sanskrit shloks and everything with photographs were pointed out and filed before the Indore High Court. And we argued before the Indore High Court that as per Section 16 of the ASI Act 1958, the religious character of the premise in question has to be determined by way of a survey. I argued the matter before the Indore High Court, and my arguments have been accepted by the Honorable Indore High Court. The Honorable Indore High Court has directed a 5-member team, which will be headed by the director or additional director of the ASI, to conduct this survey. The Honorable Indore High Court has directed the ASI, this team of 5-member committee, to submit a report within 6 weeks. GPR survey, GPS survey, excavation, carbon dating or other dating methods have also been directed by the Honorable Indore High Court. And after this report is submitted, it will be ascertained that what is the religious character of this premise in question. And then the order of 7th of April 2003 passed by the ASI will be adjudicated by the Indore High Court. Let me tell you that there is an order of ASI of 7th of April 2003 wherein the ASI has directed Hindus to offer worship in the premises in question on every Tuesday. And the same order directs the Muslims to offer namaz in the same premise on every Friday. So this is the very controversial order, and this is an illegal order in violation of Article 14 and 25. So all these matters and all these arguments were submitted by me before the High Court, and now after this survey, this picture will be more clear.
Vishnu Shankar Jain, let me also ask you this question with regards to the order that was passed by the Archaeological Survey of India allowing the Tuesday prayers at the Bhojshala complex in Dhar, that resulted in massive escalation and also, of course, the demand that were also put out by the Hindu groups. Muslim side, on the other hand, have been arguing the fact that there is no historical evidence to suggest that prayers have taken place in the past. How have you countered that?
See, the original idol of Ma Vagdevi is still with the ASI. When there was an excavation which was conducted in the past, Lord Hanuman's idol have come out from this premises in question. When you are showing it on your TV screen, in the middle of this premise, there is a Yagya Kund, Havan Kund, which you will find in any Hindu temple. All the pillars are belonging to Hindu temple. There are so many historical records and historical versions and travel accounts which show and tell that this was a site of Ma Vagdevi, the original Hindu temple, which was built by Raja Bhoj of Parman dynasty. So all those historical records have been filed by us before the Honorable Court, but it is not very important. It is not sufficient that through historical records only a matter can be solved in the court. Therefore, apart from historical record, an immediate fact-finding commission is required, a fact-finding committee is required, And that's why the Indore High Court has directed the ASI to conduct a survey in this premise in question and submit a report before the Honorable High Court. So if Muslim side is saying that this is a mosque and this is a site of a mosque, they are also free to raise their submissions before the 5-member committee of, and they can show that how this mosque was built, who has built it, the pillars and Sanskrit shlokas which are there in this premise in question. Do they belong to a mosque? When was this mosque built? All these things will be decided and seen by the committee, and the committee will submit a report before the court. So according to me, my submission is this, that this entire premise in question which you are showing on your TV screen right now is a premise of a Hindu temple. By no stretch of imagination, it's a mosque. And if anyone is saying it's a mosque, they can obviously make their submissions before the ASI and before the Indore High Court, and ultimately it's the Honorable High Court who has to decide the validity of 7th of April 2003 orders.
Vishnu Shankar Jain, I also want to ask you two specific issues. One, with regards to what Maulana Kamaluddin Welfare Society have been arguing, they have raised the objections. Second, the assessment that was actually done by the Archaeological Survey of India back in 1902 and 1903, where they did not have, there were no objections that were basically raised for a scientific understanding of the current complex. Now, to both, how is it that you all have put across your arguments? Because these arguments have happened in the past too. It has come to the limelight, to the fore right now, of course, keeping in mind what we are witnessing in Gyanvapi. But two very important issues. One, with regards to the survey that was carried out by the Archaeological Survey of India back then. And secondly, the arguments that have been put across by the Muslim Welfare Society.
See, first of all, let me answer both of the questions. So far as Kamal Maula Dargah is concerned, they had challenged the locus to file this petition before the Indore High Court. They said, and right now what you are showing on your TV screen, this Kamal Maula Dargah is outside this temple premise. It is not within the temple premise. So their basic argument is that petitioners have no locus to file this petition before the Indore High Court. And this matter should be argued or go to the Jabalpur High Court. But we have also told before the Indore High Court that this premise in question is located within the territorial jurisdiction of Indore High Court. So therefore, this matter has to be decided by the Indore High Court. So precisely their contention was not on merits. Their contention was on technical grounds, which has been rejected by the Honorable Indore High Court. Point number two, there was no survey. Let me clarify, sir. With greater sense of responsibility, there was no survey which was conducted by the ASI in 1902. It was just a mere study. After giving the premises in question, some of the members of the ASI had given an opinion. And if you will see the scope and direction of the Indore High Court in the present order, all these exercises were not conducted by the ASI back then in 1902. They did not have that kind of technology to do this kind of survey, and the scope of that survey, there was no survey as such. It was just a mere normal study which was there in 1902. So that also we have differentiated before the Indore High Court, and in this present order, the Honorable High Court has dealt with the issue of 1902 survey. And let me tell you, again I am telling it with lot of sense of responsibility, there was no survey in 1902. It was a mere passing study which was part of the record of the ASI, and the scope of present survey is much more larger and much more exhaustive and extensive than the small study which happened in 1902.
Before I take the other question, a quick follow-up on what I wanted to also do is with regards to the contours of this entire survey that is going to be carried out. Are there any restrictions to the survey that has been ordered, or would this basically entail each and every nook and corner of the complex?
Each and every part of the complex will be within the domain of the expert committee. Let me also tell you that this premise is already within the control of the ASI. So the 5-member team of the ASI has to conduct the survey within the premises in question, within 15 meters. Apart from that, the court has directed the GPR survey. Also, the court has directed excavation, dating methods from various modern techniques, and submit a report before the Honorable High Court within 6 weeks. So this is the scope and the mandate given by the Honorable Indore High Court. And the survey can start at any point of time because 6 weeks have been given. And then when the survey starts, let me also tell you this entire proceeding will be videographed and photographed. And then the report will be submitted before the Honorable High Court. Both the parties, the Muslim side and the Hindu side, 2 representatives from each community have been allowed and permitted by the Indore High Court to be present in this survey.
Mr. Vishnu Shankar Jain, there was also another argument that was essentially put forth, and that is, if we continue in the manner we are essentially right now, there will be no end to it. That is the reason why top functionaries of the RSS also had indicated that perhaps after the Gyanvapi dispute comes to an end, and also what really happens in Mathura, perhaps we'll have to bring an end to this. And also the argument of Places of Worship Act. So do you think that if this continues, perhaps there will be no end to the number of pleas that we see from several areas which are still considered to be completely disputed between the both sides?
See, first of all, the question is very, very legal. If there is, whether the site which you are showing on a TV screen, is it a site of a Hindu temple or is it a mosque? And suppose it's a site of a Hindu temple, and Hanumanji's idol is still present there, Ma Vag Devi's idol is still present there, then is it valid and legal to offer namaz there? This is the primary question. And this question of magnitude and quantity does not matter, because if the settled legal principle is property vests in the deity, till the end of the time it remains deity's property. If this is the legal proposition which has been laid down by the Honorable Supreme Court in Ram Janmabhoomi case, if this is the legal principle which is there in V.K. Mukherjee's Hindu law and P.V. Kane's Dharmshastra, then it has to apply across the board. You cannot say that you will only, for me, Kashi, Mathura and Ayodhya is very important. Apart from that, other temples are not important. No one can give concession on behalf of others. For example, if you are taking this case for the people of Indore and for the people of Dhar, Madhya Pradesh, this temple is very, very significant to us. How can I give a concession that after Bhojshala, I will not contest any other case which is there in Adina Masjid in Bengal? So cases are there, and when cases are there, it means that there is a contentious legal issue which has to be decided by court of law. And we are going through a democratic process. And democratic process is that we are taking our research before the honorable courts, before the High Court or the Civil Court. And then after adjudicating the contentions raised by both the parties, these kind of orders are being passed. So it is not that that we are taking up issues which are no evidence as such. The things which you are showing on your TV screen, this itself is very glaring and shows that this is a site of a Hindu temple. And therefore, if it is a site of a Hindu temple, why can't it be restored and reclaimed? This is point number one. Second issue which you asked about Places of Worship Act, sir. Please, my respectful submission is that Places of Worship Act 1991 cannot be read in isolation. It itself grants an exemption to the sites which are protected by the ASI. This site of Bhojshala is protected by ASI. So Places of Worship Act is not attractive so far as Bhojshala's case is concerned. And let me tell you, the Honorable Allahabad High Court on 19th of December has passed an order that religious character can be ascertained by the under the Places of Worship Act itself. So the Places of Worship Act is a narrative. We are actually driven by narrative of Places of Worship Act, but we do not read the statutory interpretation which is there in India.